A 68-year-old veteran in Florida walked into a gun store last month. He'd been carrying legally for over 40 years. Clean record, honorable discharge, zero issues with the law. But when a local firearms expert told him his new medication made his ownership illegal, he was heartbroken. He felt like a second-class citizen in the country he served. He was ready to hand over his entire collection, 40 years of history. Here's the truth. He wasn't breaking the law. The expert was just wrong, and that veteran isn't alone. Right now, thousands of senior gun owners are walking around thinking they've lost rights they actually still have. Or worse, they're paying fees and jumping through hoops they're legally exempt from. Since the Supreme Court's Bruin decision reshaped concealed carry laws across America, dozens of states have quietly updated their firearm statutes. Buried in that new legislation are protections, exemptions, and rights written specifically for older Americans. But here's the problem. These aren't advertised. They're not posted on the wall at your local range, and most attorneys, even Second Amendment lawyers, don't specialize in the intersection of gun rights and senior citizen law, so these benefits just sit there, unused, unknown, while seniors continue paying fees they don't owe, following rules that don't apply to them, and missing out on legal protections they've already earned. I've spent months digging through state-level firearm codes, federal disability law, the Americans with Disabilities Act, veteran benefits programs, and court rulings from the last 5 years. What I found was a pattern. There are specific protections written into federal and state statutes that act like a legal shield for seniors, but because these rights don't generate massive legal fees for lawyers, they stay buried in the fine print. Before we dive in, let me be clear. I'm not a lawyer, and this is not legal advice. Gun laws vary by state and change frequently. Always consult with a licensed attorney in your jurisdiction and verify current statutes before taking action. This information is for educational purposes only. What I'm about to share with you are 10 forgotten rights that can save you thousands of dollars, protect you from administrative overreach, and even grant you carry privileges that the average person can only dream of. And pay close attention when we get to number 7. It's the one right that prevents the government from using your checkbook as a reason to take your guns. Let's break down the 10 forgotten senior gun rights that are hiding in plain sight. Number 10. If you served in the military and you're over 62, there's a very good chance you're exempt from concealed carry training requirements, and nobody's bothering to mention it. States like Tennessee, Kentucky, and South Carolina have all passed legislation in recent years that waives the classroom and range qualification for veterans who meet specific age thresholds. The logic is simple. If you've already been trained in firearms handling through military service, the state shouldn't make you sit through a civilian course decades later. But here's where it gets buried. These exemptions aren't automatic. You have to specifically request them when you apply, and if you don't mention your veteran status and age at the counter, the clerk will just hand you the standard application, complete with the training requirement box checked. I spoke with a licensing officer in Knox County, Tennessee, off the record. He told me that less than 15% of eligible veterans actually use this exemption. Why? Because they don't know it exists. Here's what you need: your DD-214 discharge papers, proof of age, and knowledge of your state's specific statute. In Tennessee, it's TCA 39-17-1351. In Kentucky, it's KRS 237.110. South Carolina has it under Section 23-31-215. You aren't just saving the $150 in training fees. You're avoiding being put on new student registries that many modern training facilities maintain. You've already proven your competency. Why pay to prove it again? The key takeaway? If you're a veteran over 62 and applying for a concealed carry permit, do not assume you need training. Call your state's handgun licensing division directly and ask about veteran exemptions by age. This is what's known as competency equivalency, and it recognizes that your military service already demonstrated firearms proficiency. Number 9. This is one of the most dangerous myths circulating in senior gun communities, and it's causing people to surrender their rights for absolutely no legal reason. Let me be crystal clear. Taking medication for anxiety, depression, PTSD, or even early-stage dementia does not automatically disqualify you from owning a firearm under federal law. Not automatically, not even close. The actual federal standard is found in 18 U.S.C. Section 922 G4. It prohibits firearm possession only if you've been adjudicated as a mental defective or committed to a mental institution. Both of those require a judge or formal legal process. A prescription from your doctor doesn't come close to meeting that threshold. Yet every year, thousands of seniors voluntarily give up their guns because a family member, a well-meaning friend, or even a doctor tells them, "You're on medication now. You can't have guns anymore." That's not the law. That's fear. Now here's the part attorneys won't clarify unless you press them. Some states have red flag laws or mental health reporting requirements that operate differently. And yes, if a court orders you into involuntary treatment, that's a different story. But simply being prescribed Prozac, Xanax, or Aricept, not disqualifying. There was a case in Pennsylvania in 2021 where a 74-year-old man's firearms were confiscated after his son told police his father was on dementia medication. No court order, no hearing, just a concerned family member and a misunderstanding of the law. It took him 9 months and $8,000 in legal fees to get his guns back. Bottom line, if you're on medication, don't assume you've lost your rights, and don't let anyone, family, friends, or authorities convince you otherwise without a court document in hand. Number 8. If you've got age-related hearing loss or vision impairment, you're not just entitled to accommodations during a firearm purchase, you're legally protected when you request them. Under the Americans with Disabilities Act, gun stores are places of public accommodation. This means they are legally required to provide reasonable accommodation for age-related changes, not as a courtesy, as a requirement. I've seen gun store clerks get impatient with seniors. Maybe the lighting was poor, the print on Form 4473 was too small, or your hands aren't as steady as they used to be when filling out those tiny boxes. In some cases, clerks have even denied a sale because they claimed the buyer seemed confused. This is a violation of your federal rights. What does reasonable accommodation look like in practice? You can ask the clerk to write down questions instead of asking verbally if you have hearing loss. You can request they speak louder or slower. You can ask for better lighting, a magnifying glass, or even a chair to sit in while you complete the form. You can bring a trusted friend or family member to help interpret instructions. And the store cannot deny your purchase just because the process takes longer or require extra steps. They cannot treat your age as a disqualification for a sale. If you ever experience impatience or pressure, use this exact phrase: I am requesting reasonable accommodation under the ADA to complete this paperwork at my own pace. That sentence changes the entire conversation. It puts the store on notice that you know your rights and you're invoking federal protections. The tone of the room will change. Under the law, if they refuse appropriate accommodation or deny a sale based on age-related conditions, they aren't just being rude, they're breaking federal law. Before we continue, quick question. Are you getting value from this? If so, hit that subscribe button right now. This kind of content doesn't show up in the mainstream. It's not profitable for lawyers to break this stuff down, and it's definitely not something gun stores are advertising, but it matters. So if you want to stay informed on your rights as a senior gun owner, subscribe now and turn on notifications. Number 7, we've arrived at the most critical part of this list. If you take nothing else away from this video, let it be what I'm about to tell you. There is a quiet concern among seniors who have representative payees, someone like a child or a spouse who helps them manage their social security or pension. For years, there has been confusion about whether needing help with your checkbook means being mentally incompetent to own a firearm. Here's the forgotten right that keeps the government out of your safe. In 2017, a massive victory was won for seniors, but the mainstream media buried it. A federal rule was repealed that would have automatically sent the names of Social Security recipients with representative payees to the NAICS background check system as prohibited persons. Under current federal law, and reinforced by the Social Security Fairness Act updates of 2025, administrative help is not a legal disqualifier. Here is the line they won't tell you. Unless a judge in a court of law has issued a formal order declaring you adjudicated as a mental defective, your rights are 100% intact. A doctor's note isn't enough, a Social Security clerk's opinion isn't enough, and having your daughter sign your checks is definitely not enough. If you are ever questioned by an agency or a facility about your firearms, you must state, "I have never been adjudicated incompetent by a court of law." That phrase is your legal firewall. It stops the administrative overreach dead in its tracks. This protection is sometimes called the payee protection precedent, and it's one of the most important safeguards for seniors who need financial assistance but want to maintain their Second Amendment rights. Number 6, nearly every state with a concealed carry permit system offers reduced fees for seniors, but most won't advertise it on their website or mention it at the counter. Let's look at real numbers. In Louisiana, a standard 5-year concealed carry permit costs $125. If you're 65 or older, it drops to $62.50. That's half price. And the lifetime permit, normally $500, is just $250 for seniors. Alabama offers lifetime pistol permits for $300. Seniors 60 and up, $150. Ohio charges $67 for a standard concealed carry license. Seniors often qualify for a $50 discount depending on the county. Michigan, Florida, and Nevada all have similar programs, but you'd never know it unless you dug into the fine print or called the licensing bureau directly. Why the silence? Because state budgets benefit when people pay full price. It's not a conspiracy, it's just how bureaucracies operate. They're not incentivized to save you money. Here's the other part that matters. Some states tie the discount to income, not just age. If you're over 62 and on Social Security or a fixed income, you might qualify for an even deeper reduction. States like Virginia and North Carolina have sliding scales based on proof of retirement or veteran status. And it's not just government permits. You've likely seen the ads for the big gun rights organizations. They want your support and they want your dues. But what they don't put in the glossy brochures is that once you hit 65, you qualify for distinguished status that slashes prices by up to 66%. Take the NRA, for example. In 2026, a standard life membership can run you $1,500. But if you are 65 or older or a disabled veteran, you can jump into the distinguished life membership for just $750. The Second Amendment Foundation and Gun Owners of America have historically offered senior rates if you call their membership line directly rather than just clicking the join button online. Here's your action step. Before you apply for or renew a concealed carry permit, call your state's licensing office. Don't ask, "Do you have discounts?" Ask this instead. "What is the senior rate for applicants over 60 and what documentation do I need?" That second phrasing assumes the discount exists, and 9 times out of 10 you'll get a straight answer that saves you real money. Never join or renew organizational memberships online using the default buttons. Call the membership department and ask for the distinguished or senior rate for your age bracket. You will save hundreds of dollars in under 5 minutes. Number 5, if you've been buying a hunting license every season for the last 40 years, there's a very real chance you've been overpaying and the state has been letting you. Dozens of states offer free or heavily discounted hunting and fishing licenses to seniors, but they don't exactly put up billboards about it. Many seniors assume that because they've stopped hunting regularly, their old licenses are useless. Or worse, they want to take their grandkids out for a weekend, but are put off by the $100 plus price tag for modern tags and permits. Several states have what's known as a pioneer license. In states like Oregon, if you're 65 and have lived there for 50 years, you don't just get a discount, you get a pioneer status that covers hunting and fishing for a fraction of the cost. In Louisiana, as of 2026, if you were born before June 1st, 1940, your license isn't just discounted, it's free. Florida is one of the best examples. If you're 65 or older and a resident, your driver's license becomes your hunting and fishing license. No additional fees, no separate cards. You're automatically covered for freshwater fishing, saltwater fishing, and most game hunting. Georgia exempts anyone born before January 1st, 1961 from needing a hunting license at all for small game. You still need tags for deer and turkey, but the base license, waived. Arkansas offers free lifetime hunting and fishing licenses to residents 65 and up. One-time application, zero cost, done for life. But these programs operate on the assumption that you'll either not know or not ask. I've spoken with wildlife officers in 3 states who've told me the same thing. Most seniors keep paying because they assume the rules haven't changed since they started hunting decades ago. Here's your move. Go to your state's Fish and Wildlife website and search the term exemptions rather than licenses. Look for senior programs or pioneer licenses. If you can't find it, call the licensing office directly and ask, "What are the senior exemptions for hunting licenses in this state?" You might discover you've been paying $100 to $200 a year for something you've already earned the right to do for free. Number 4, if you live in a restrictive state, you've likely been told that getting a carry permit is nearly impossible or costs upwards of $500. Here's the forgotten right. You do not have to be a resident of a state to hold their permit. This is the non-resident senior strategy. States like Arizona and Florida have a specific senior processing track for non-residents. Why this is a game changer. As a senior, you can apply for a Florida non-resident permit by mail. Because of your age and established record, which they verify through a simplified background check for those over 60, you can often bypass the live fire requirements if you have that old hunter safety card we talked about earlier. Once you have that Florida or Arizona card, you suddenly have legal reciprocity in over 30 states. You've bypassed your own state's red tape and high fees by using a federal recognition system designed to keep seniors mobile and protected. The key is understanding how reciprocity works. Many states honor out-of-state permits, and by strategically obtaining a non-resident permit from a state with broad recognition agreements, you effectively unlock carry rights across most of the country. This approach is particularly valuable for seniors who travel frequently, own RVs, or split time between multiple states. Just make sure you verify which states honor your non-resident permit and understand any restrictions that apply. Number 3. If you're a retired cop or former military police officer, you have access to one of the most powerful gun rights in the country, and there's a good chance you've never activated it. It's called the Law Enforcement Officers Safety Act, or LEOSA, also known as H.R. 218, and it grants qualified retired law enforcement and military law enforcement the right to carry a concealed firearm in all 50 states without needing a state-issued permit. Read that again. All 50 states, no reciprocity issues, no state-by-state permit applications, you carry nationwide. Most people think you had to be a full-time beat cop for 25 years to qualify. That is a myth. Under the 2026 standards, if you served as a qualified law enforcement officer, which includes many military police roles, certain federal park rangers, and even some special deputies, for an aggregate of 10 years, you qualify. Here's what you need. 10 years of service as a law enforcement officer or military police, retired in good standing, not separated for misconduct, annual firearms qualification through your former agency or approved instructor, official photo ID issued by your former department. That's it. Once you have those 4 things, you can legally carry in California, New York, New Jersey, Hawaii, states where regular civilians face months of bureaucracy and may still get denied. According to a 2022 survey by the Fraternal Order of Police, nearly 40% of retired officers don't even know LEOSA exists, and of those who do, many never complete the annual qualification because they assume it's complicated or expensive. It's not. Most retired officer associations offer free or low-cost qualification shoots specifically for LEOSA credential renewals. If you served in any law enforcement or MP capacity, don't assume you're excluded. Contact your former agency or a LEOSA certified instructor. The 10-year rule is a lower bar than most realize. This is the closest thing to a golden ticket in the firearms world. Don't let it sit unused. Number 2. This is a legal nuance that could be the difference between a clean self-defense case and a criminal charge. In several states, mandatory safe storage laws contain exemptions for seniors, especially those living alone. California, Massachusetts, and Washington all have laws requiring firearms to be stored in locked containers or with trigger locks when not in use. The stated goal is preventing access by children or unauthorized users. But if you're over 65 and living alone, some of these laws explicitly carve out exceptions. Why? Because the legal rationale for safe storage is preventing access by others. If there are no others in your home, the justification disappears. In California, Penal Code 25100 requires safe storage, but only when someone under 18 could gain access. If you're a senior living solo, that condition doesn't apply. You're legally allowed to keep a loaded handgun in your nightstand without a lock. Massachusetts General Law, Chapter 140, Section 131L has similar language. The requirement is triggered when a minor or prohibited person resides in the home. Live alone? The law doesn't bind you the same way. But here's the catch nobody explains. If you ever have grandchildren visit even overnight, that exemption disappears. And if something were to happen, prosecutors will absolutely argue you should have known better. So what's the smart move? Know your state's exact safe storage statute. Understand when exemptions apply and when they don't. And if you're a senior living alone who keeps a firearm accessible for self-defense, document it. Keep a simple written statement that says, I live alone. No minors reside in or regularly visit this home. It sounds overly cautious, but in a courtroom, that one piece of paper could demonstrate you understood the law and acted within it. Number 1. This is the most important legal concept for every senior gun owner in America, and it's the one that levels the playing field in a courtroom if you're ever forced to defend your life. There is no maximum age for firearm ownership or purchase under federal law. None. You can be 70, 80, 90, or 100 years old, and as long as you're not prohibited for another legal reason, your age alone cannot disqualify you. Yet every year, seniors are turned away from gun stores, denied permits, or pressured into voluntarily surrendering their firearms simply because someone decided they're too old. That's illegal. Federal law is clear. The only way you lose your gun rights is through a felony conviction, a domestic violence conviction, involuntary commitment to a mental institution by court order, or being adjudicated mentally incompetent by a judge. Notice what's not on that list? Age, taking medication, using a cane, living in assisted housing, having a representative payee for Social Security. If a gun store clerk, a law enforcement officer, or even a family member tells you that you're too old to own a gun, they are wrong. And if they take action based on that belief, they may be violating your civil rights. There's a documented case out of Michigan in 2020 where an 81-year-old woman was denied a handgun purchase because the store owner said, "I just don't feel comfortable selling to someone your age." She filed a federal discrimination complaint. The store settled quietly. But here's where this gets even more powerful. It's called disparity of force. The law recognizes that as we age, we face physical frailty and diminished capacity to defend ourselves with our hands. If you are 25 years old and you use a firearm against an unarmed attacker, you might face serious legal scrutiny. But if you are 70, the rules change. The legal reality is this. If a 20-year-old intruder enters your home, even if he is unarmed, the law often views his youth and vitality as a weapon against your age and vulnerability. You have a legal right to escalate to a firearm much faster than a younger person would. In a courtroom, your age isn't a weakness. It is your justification. It turns what might be questioned as excessive force into a legally recognized defense of life. This applies whether you're in your own home under castle doctrine or in public where you have a legal right to be. Courts have repeatedly recognized that seniors cannot be expected to engage in hand-to-hand combat with younger, stronger attackers. Your age creates an inherent disparity of force that justifies the use of a firearm for self-defense in situations where a younger person might be expected to use less force. If you're ever in a self-defense situation, your first words to your attorney should be, "I was in fear for my life due to the disparity of force between my age and my attacker's strength." Those words frame your defense in legal terms that courts recognize and respect. Lawyers don't always emphasize how powerful this defense is because it can end cases quickly, but it's one of the most important protections seniors have. And there you have it. 10 senior gun rights that are written into law, protected by court rulings, and actively underutilized by the people who've earned them. From veteran training exemptions to nationwide carry under LEOSA, from medication myths to the simple fact that your age alone will never disqualify you. These aren't loopholes, they're your rights. But here's the reality. The system runs on silence. Gun stores make more money when you pay full price. Licensing offices process more applications when you don't ask about exemptions. And attorneys bill more hours when you don't know the law yourself. Nobody's going to hand you this information. You have to go get it. So here's what I want you to do. Pick one item from this list, just one, and verify it in your state this week. Call your concealed carry licensing office. Check your state's hunting regulations. Pull out your DD 214 and see if you qualify for a training waiver. Look up your state's safe storage laws if you live alone. Take one action. Because knowledge without action is just trivia. You've spent a lifetime following the rules. You've paid your taxes, raised your families, served your country, and respected the law. It's time the law started working for you. From the ADA protections at the gun counter to disparity of force in the courtroom, these 10 rights are your inheritance. They are the protections that the system hopes you never find. Your rights don't have an expiration date, and unless a court has specifically stripped them from you through due process, no one, store owner, cop, or lawyer, has the authority to take them based on how many birthdays you've had. Stay armed, stay informed, and never let anyone tell you you're too old to exercise the rights you've spent a lifetime defending.